I will now call the first case on the docket. Case number 117149, Royce Williams v. Geico General Insurance Company.
May it please the court. Your honors, my name is Theodore C. Davis. For the appellee Royce Williams, I request 5 minutes in rebuttal.
5 minutes. 5 minutes is granted.
Thank you, your honor. Procedural posture for this case was originally a case filed in Sedgwick County as a Chapter 61 contract dispute for the payment of PIP benefits. Cross motions for summary judgment were filed at the district court level. Royce Williams plaintiff won the cross motions that essentially boiled down to the same issue that's before the court today. The Court of Appeals reversed the district court's ruling, and then the Supreme Court granted this hearing today. I've been up since 4:30 and had a lot of coffee, so I will already just jump right into that one issue, which is whether or not a person in a spousal relationship has a pre-existing duty to perform certain tasks that would preclude the payment of PIP benefits under KIRA to a spouse. And so,
excuse me, counsel, before you continue, for the benefit of our audience here and those watching elsewhere, could you explain what kind of a case this is? You've talked about PIP benefits, but I don't know that everybody knows what that is.
Absolutely. So what occurred was Royce Williams was severely injured in a motor vehicle collision, which occurred on December 5th, 2015. When he returned home from the rehabilitation hospital on December 18th, his wife, Mary, began providing him with certain services and care that he was not previously in need of. And they submitted a claim to their automobile insurance company, Geico, the defendant at district court level and the appellant today. The benefits were paid under the Kansas Automobile Injury Reparations Act, or that was the claim that they should have been paid under a personal injury protection benefit policy purchased by Royce and Mary Williams to be paid in the event of a motor vehicle collision. For the benefit of those who don't know, these are Kansas no-fault benefits to be paid regardless of the fault of the issue of the person involved. That's the classic Kansas being a no-fault state. Those are those benefits. So that's the basic nature of the case. Those benefits were denied payment to Royce, or ultimately to Mary Williams, the person doing the services, based on the idea that Geico said initially that they were, it couldn't be paid by a household member. Throughout the course of litigation, that got focused to it was the spousal relationship that made the payment of benefits something that they weren't obligated to do under the law, based on the fact that Mary had a pre-existing legal duty. Which brings us to the case law established under Hefner, where custodial grandparents were given or were paid ultimately through that case benefits for taking care of their grandchild who was disabled after their mom was deceased as a result of a motor vehicle collision when they took custody. So the mother of the disabled child dies as a result of motor vehicle collision, and then the grandparents take custody of her, care for her, ultimately adopt her, but the court says in Hefner that because she didn't have a legal duty or the grandparents didn't have legal duty, they were entitled to payment of those benefits. And I think that's the moment where I have trouble with Geico's characterization that somehow that's exclusively what Hefner is about. The statute says you must incur economic loss in order to be entitled, and the court goes on to define that as to incur, you must have genuine economic loss. Okay, the factors that ultimately get argued at both the district court level in this case, as well as by the appellate court, and to a certain extent in Hefner, are the issues of an absence of a pre-existing legal duty to provide the services, and that's ultimately what we're arguing about here, not the other factors. So I won't spend time on that if you don't want me to, because I don't think they're necessarily important. But what I do think is important is that it's not a checkbox in Hefner. I don't read Hefner as a checkbox like that to say you must have this and then check the box here and check the box there. They're talking about whether or not there's genuine economic loss. And going back to the fact that you've got this, the idea that somehow custodial grandparents of a disabled child don't have some duty to perform care, I think flies in the face of what the reality of what would happen. You know, the Geico has used criminal law to say there's some existing duty in the case of the spousal relationship, but the court found in Hefner that these grandparents didn't have a duty. That doesn't make sense. How did they not have a duty? Certainly they would have been held criminally liable for not taking care of a child that they took custody of. I think the issue here is that just to say you had a duty to care or a duty to pay or a duty, that's just using that word duty as some kind of overarching thing. And if you had one duty, you must have all duties. Well, that's not how it works. And you have specific duties in specific cases. And the issue here is that Mary Williams provided certain things to her husband that she didn't previously provide. They both work in the aircraft industry. They work separate hours. They didn't do each other's laundry. They didn't do each other's meals. He didn't need to be driven everywhere before he got hurt. He didn't need medicine administered before he got hurt. Those were not things that they did. That was not part of their marital relationship before.
So if it were, would that make a difference?
I don't think it necessarily would make a difference, and the reason being is that I don't think that they should be prohibited from having.
Your point is it's economic loss. It doesn't matter what roles they play in their specific marital relationship, does it?
I don't think it. Ultimately, I do not think it does, because I don't think that Hefner necessarily stands for the proposition there must be genuine economic loss.
Right.
True, but I don't think that it stands for the proposition that there's an exact way to formulate that. And I know they discuss those factors, but maybe that's a flaw in the way I initially framed some of these arguments at the district court level, in that, you know, using it as a checkbox. I don't know if it does that. It does talk about those things.
But here, as I understand the facts, didn't your clients or your client prepare? They documented the economic loss. They kept specific time and charts and allocation of economic resources that were spent with the care, didn't they?
They did. They had a form that they put dates and the amount and what the tasks that were done, and then submitted that in writing to Geico.
But they also had an agreement underlying it that she would be paid, right?
Right, that was.
So here's my question. It kind of follows up on what Justice Rosen just asked you. I'm a little confused at this point on your argument, because it seems to me that your winning argument potentially is that each case is fact specific, and that a couple but this is the part I'm concerned about, so a couple who have arranged their lives in a specific way before the accident may be treated differently from a couple who arranged their lives in a different way before the accident. Or can any couple decide to arrange their lives in a specific way post-accident and then drive this particular legal issue? So, for example, let's say your client and his wife didn't have this sort of separate finances, in many ways separate personal care kinds of life before the accident, but that after the accident that was necessary. And so the wife said, you're going to get a good deal if I provide the services, as opposed to we hire all this out to professionals to come and give you this care, this home care basically. So let's say their prior life didn't look the way that it did, but it looked the way that it does afterward. Is that sufficient under the statute? I mean, is this a fact question, really?
Well, I think it did if you can show economic loss. I think that's valid in that.
So the economic loss can arise post-injury. It isn't necessarily dependent on how they arranged their lives before the accident. That's your opinion?
Well, right.
Okay.
Is the critical factor then that the married couple entered into a contract? Is that what would trigger this statute?
With whom, Your Honor?
With each other?
With each other. I think that is not, I don't believe that's the critical factor, because I think that when one spouse has to adjust their life to provide things they didn't previously provide, for instance, that may mean taking off work to go do those things. And so that spouse isn't entitled to a lost wages claim in this scenario. Their only option is this essential services or substitution benefits. They don't get that. So they've incurred that economic loss in more than one sense, but certainly in the marital sense, because the one has stopped working in order to provide those services. I mean, that's one example, but I mean, I think that's it. There's more than one way to have genuine economic loss, and I think Hefner goes that far, genuine economic loss, but not necessarily establishing those things as an absolute checklist for requirements to establish it.
And there was some lost wages here, I believe the record establishes. Is that correct?
There's not a claim for it, so I don't have the paperwork. Royce definitely. For Mary, she did have to take time off of her work, but there's no formal claim for her lost wages in that true sense.
So under these facts, is the contract essential for the recovery?
I think under these facts, if you read into it a requirement to notify GEICO in paper form, then potentially yes.
Do we know whether or not Mary would have performed these services had she not been paid?
Would she have performed these services if she had not been paid?
I don't see anything in the record that would point us one way or the other.
I don't know the answer to
And
that
isn't
question.
that a fact that we have to know in order to determine whether or not there's true economic loss? It seems to me that's the crucial fact.
I'm not sure, Your Honor, on that. I do know.
Well, let me
that-
re-ask the question. How can you establish at the summary judgment stage that this is economic loss without that fact?
Well, I do know that she had to take time off work, and I think that by itself.
But if she would have provided these services, even if she had not been paid, there's no economic loss. I mean, that would seem to be the logical conclusion.
Well, I do know that there was an agreement expectation of payment, so I think that there is.
All of that was just papered up so that they could submit the claim, was it not? I mean, at least arguably.
I mean, I guess arguably, sure. I don't think that that's the nature of the situation.
Oh, okay.
Let me parse the facts just a little bit, and it gets over to what Justice Rosen had asked about that, and Justice Beyer, the way this couple had arranged their lives. There's repeated reference in the court decision, the Court of Appeals decision, about that the husband did all these services for himself before because they had separate shifts or separate work, and so she stepped in to do that. When I look at the uncontroverted facts coming from the district court, I actually don't see that particular fact. You guys stipulated you ended up sort of impliedly stipulating, and the court found certain uncontroverted facts, and by adopting certain paragraphs from your competing motions. And when I track through what you all alleged, I'm not seeing that particular fact as being uncontroverted. So number one, is that right? And number two, is it critical if it isn't?
I don't know that it's critical, and I cannot tell you that it was on the list of uncontroverted facts or not. And you're talking specifically about the fact that the third shift, first shift type of scheduling.
Just the fact, you do have in your uncontroverted facts specific things that Mary did, laundry, that kind of thing. That we got. What I don't see in what was uncontroverted is this notion that the husband used to do those things for himself, as opposed to Mary had the job of, like a lot of couples do, has the job of doing one thing versus the other spouse doing other things. See what I'm getting at?
Right, and what I think was uncontroverted, and I may be incorrect, of course, but the fact that Mary had not previously done those things, and so I think the inverse reference there is that.
I'm just not seeing that either.
Okay.
Okay.
All right.
But let's assume it's not there, and you say it's not critical, which I think gets us to Justice Byers' question about how case specific the issue has to be. So,
Well, I mean,
get me there.
If you took for true that a spouse has the duty to perform these items, if you took that argument by Geico that is true, which I don't agree with, especially since I'm on the web and my wife might watch, but if that is true, then if that person is unable to perform those duties that are required, as Geico argues, then at the point where Royce is unable to do them himself and his wife Mary has to do it instead, thereby decreasing the economic capacity of those two people together, haven't you suffered economic loss? I mean, I'm not conceding she has those duties, but I'm saying if you concede that she does have those duties, I think I win right there, because you automatically decrease their economic capacity, and then you have economic loss. So I think you could fact specific this case or these type of cases, but I do think there's a bigger issue here that could be addressed and should be addressed to determine whether or not that's even possible under the laws it states.
Yeah, I mean, but I want to be careful. I don't like answering questions that aren't actually asked in a case.
Sure.
And so that's why I'm kind of drilling down into what's actually happening in this relationship and whether it matters.
Well, I mean, if you think about a case like Wentling or something like that, where people go in and try to quantify what is the value of being a parent, what is the value of tying your kid's shoes. You have an economist, you come in, and it is extremely fact specific, where how do you determine the economic loss of losing a parent? Well, you come in and you describe that parental relationship and every detail that might occur in that person's life, and what would it cost for you to go out into the world and come up with those numbers, right? And that's how you prove that type of fact-specific loss of economic recovery. And so, I mean, maybe it is a situation where it is extremely fact-specific.
Your point is you win either way. Your point, what you're arguing today is I win if we make it a very fact-specific inquiry, peculiar to each case, but I also win if we're in the theoretical realm of more of a Wentling kind of a damage, a loss of economic power, basically, in the marketplace.
Right, absolutely, because I think there was true economic loss in this
How do you
scenario.
connect your broad economic loss theory to 3103? Because as I read it, it's much more narrow.
Well, I think the way I do is because this requirement that there not be a pre-existing duty is something that's added in later.
Sure, but I'm just you're making a broad. If we suffered some kind of economic loss as an economic unit, we can recover. But the statute only allows for appropriate and reasonable expenses incurred.
Exactly, and so that to a certain extent has been defined by case law to delve into that and hash that out a little bit. But the key here is that somebody had to do something else, and I think that's where it stays narrow with 3103W, is that what had to happen was somebody else had to go in and do something. It wasn't just that they lost power that wasn't being utilized. Somebody else had to go do the laundry, do the cooking, do the driving, do the medication.
It
And
just
the
seems to
loss.
me, oops, I'm sorry. One last question? Or do
No,
you-
I was going to ask a question.
Okay, go ahead.
Go
All right,
ahead.
I'll just wrap this one quick up. It just seems to me that you're going way farther than you need to go when you make that kind of Wentling type argument. As I think my colleague at the end of the bench is trying to say to you, you can just tie it to the wording of the statute.
Well,
And then your only point is it doesn't matter if it's your spouse or not. If it's something that has to be provided for you by someone else that didn't need to be provided for you pre-accident, and it costs money, which it did here apparently because she wanted to be paid, then that's it. That's all we need to know. If it costs the insured money to get the same services that didn't used to have to be provided by someone else, end of story under the statute. Isn't that right?
I think so, and I didn't
Okay.
mean.
I just think we were really getting far afield.
Yes, my point was you were having to make the argument that it is an expense incurred when the helping spouse has lost wages.
I think that overall scenario counts as genuine economic loss.
And
Yes.
those are not our facts. So I think Justice Byers' question is, why are you going there? Was that just in response to a question?
I feel like it was,
All right.
because I don't know if that was necessarily my plan from the get-go.
All right. I see no further
Just
questions.
real quick, a quick clarification. The maximum on this is $25 a day.
Yes, Your Honor, for 365 days after the date of loss.
Okay. Thank you.
Thank you, counsel.
Thank
We'll
you.
see you on rebuttal.
May it please the court, Lyndon Vicks on behalf of Geico General Insurance Company. The court has asked a lot of questions of Mr. Davis, which indicate that the court's coming at this from a number of different directions, so it's a little difficult to know exactly where to start. I think I want to start with this idea about the economic loss and who sustained it. What I hear the court seeming to say is that, well, Mrs. Williams sustained a loss because she lost her wages here, and is that good enough? And I think the language of the statute indicates otherwise. That the statute says that it has to be reasonable expenses incurred in obtaining other ordinary and necessary services. So it's the insured, the person in need of the services, that has to incur that economic
Yeah,
loss.
it's Mr. Williams himself.
Yes.
Yeah.
But I think you're asking us to consider the married couple as an economic whole. I mean, that seems to be the nut of your argument. But now you're asking us to segregate that and say that her lost wages doesn't affect the family?
I don't know, Your Honor, that our argument treats the spouses as an economic whole. I think it does ask the question whether in a marriage relationship those spouses can contract with each other or incur debt to each other for the normal services that they render to each other. I don't think that necessarily requires them to be treated as an economic whole. There are certain rights that are created under the law for one spouse in certain instances, such as the elective share in the decedent estate situation. And I don't think that theory is that they're an economic whole, but it's that there was a duty of support in marriage, and so that duty carries after marriage into death.
Let me ask a couple.
Yeah, go ahead.
I was going to say, since both counsel have been referring to the language of the statute, help us understand where in the statute it talks about this distinction that you draw, and that is, if you're a spouse and you're providing services under the statute, you're disqualified from recovery.
Okay, it's sort of a three-step process, perhaps. The language of the statute refers to expenses that you can recover as being those incurred in obtaining other ordinary and necessary services. From there, I think you have to go to the Hefner case, where the word incurred was parsed, and the court determined there that what incurred means is to incur a genuine economic loss or liability. And also in Hefner, they used the term debt. In Hefner, they said that the grandfather in that case regarded his granddaughter as currently owing him a debt of $9,125 for the burden of custodial care he provided to her, which he was not obligated to provide. And that's where we get to the next step. The court in Hefner, I think, made quite clear that the key in Hefner was that a grandparent is not obligated to provide services to a grandchild. And for the first time today, I heard Mr. Davis make the argument that that can't be right, that a grandparent must have that obligation. Well, I don't think that's true legally. There are a couple of relationships where that arises, and it's parent-child and between spouses. And I think our law is pretty clear on that there is a pre-existing duty of one spouse to provide services to another. We've cited a lot of cases in different situations that I think establish this overarching principle.
So on that,
Go ahead.
I want to drill a little bit into this notion of a pre-existing duty, because I agree with you, that seems to be the legal hook on which some of our case law hung its decisions, and that's the hook on which you're relying. Hypothetically, let's assume there is a pre-existing marital duty to provide services, but in this circumstance, one spouse simply says, I'm not going to do it. And the other spouse says, well, gee, you have a duty to do it, but I guess I'll pay you. Isn't that still a appropriate and reasonable expense incurred by the injured spouse? And what I'm getting at is why does the duty matter here? Isn't the question whether or not the services would have been provided absent pay?
I think the duty matters, Your Honor, is because if there has to be a genuine economic loss, there needs to be a legally enforceable liability. And if these spouses cannot legally contract in the manner that you've suggested, I'll pay you to do this.
Why can't they?
Well, I think
Why does the existence of a pre-existing duty render them unable to contract? I just don't. I can't connect that dot.
I think it's because a pre-existing duty, something you already are obligated to do, cannot provide consideration for a contract. In other words, I agree that I will do something that I was going to do anyway.
So the only alternative for an injured spouse who the other spouse says, I may have this pre-existing duty, but I'm just not going to do it. The only alternative is to sue them? Is that the only?
Absolutely not. The alternative is to hire someone from outside the home. I mean, if Mr. Williams had someone come into the house and do the sorts of things that Mrs. Williams did for him, Geico would have had no choice but to pay in accordance with the statute. That's what the statute is for. It's when you can't provide the service for yourself that you did before, you hire someone to come in, and it can be from mowing your lawn to providing.
I understand that. I guess I'm asking about this appropriate and reasonable language in the statute, and it seems to me like that's from the perspective of the injured spouse. What's reasonable and appropriate? And it seems to me it could be reasonable and appropriate for that spouse to think, I'd prefer to have my wife perform these services, and so it's reasonable and appropriate for me to pay her if she's not going to do it otherwise.
Well, Your Honor, you're reading some language in here in a way that I don't know is there. It talks about the services being ordinary and necessary. It doesn't talk about the choice being...
It talks about appropriate and reasonable expenses.
I think ordinary and necessary expenses or services.
No.
Reasonable
Appropriate.
expenses.
It starts
And
as
appropriate and reasonable expenses incurred in obtaining other ordinary necessary services in lieu of those.
It
So we
seems to
have-
me this case is not about the services rendered. There's no
Right.
dispute about ordinary and necessary services, is there?
No,
The
I don't think
dispute is
there's-
about whether or not the expense, and the expense was incurred. The only dispute here that I can see is whether it's appropriate and reasonable. Right?
I'm afraid I disagree. I think the dispute is on incurred, not appropriate and
it was
reasonable.
paid, was it not?
No, it wasn't paid.
It was incurred in the sense that there was a contractual obligation entered into.
And that's our point. It can't
have
be
a contract.
contractually obligated. If you can't make that contractual obligation, it can't be incurred.
You're just making a straight up contract argument, no consideration, because the duty pre-existed any kind of an agreement. So there's no support for the contract, no consideration to support the agreement.
Yes, Your Honor, and that's why I think the facts of the case are not important at all. The question of whether they had ordered their lives, as the court has said, in a particular way is simply not relevant to that. The law doesn't impose those kinds of duties on spouses based upon how they order their lives. The doctrine of necessaries doesn't apply or not apply depending upon how these two particular spouses decided that they would have their marriage go forward. There are
The
times
law-
when the law makes some choices for you. And I would say that in the marriage context, that is one of those instances.
The law of necessaries has arisen in the context of third parties, a debt owed to a third party. Have you found any case that applies it between the spouses?
That applies the doctrine of necessaries between the spouses.
Right. Where one spouse can claim, you have not provided me the necessaries as you're required.
I haven't, Your Honor. No, I'm not aware of a case like that.
And because it applies to the third parties, how do we bring that into the marriage relationship? How do we impose a legal duty from one spouse to another to do certain tasks in a home?
Well, I would say, Your Honor, that it's more of an overarching principle that would control here, and the principle that the doctrine of necessaries is based on is the obligation of one spouse to support another. Now, in that context, it is the support that's provided via or to a third party. But without that existing relationship that requires them to support each other, that third party couldn't benefit. And so if that relationship, the support obligation exists, it applies in this context too to say the fact that one spouse is giving services to another cannot create a contractual liability because it is already a pre-existing duty.
But in Kansas, we've limited that duty to payment of third-party creditors.
Under the doctrine of necessaries we have.
Well, that's what you're trying to rely on. You need that doctrine, don't you, to win?
The doctrine's helpful, there are others.
Okay, what's your other theory to win?
Well-
up till now, you've said the doctrine of necessaries means there's a pre-existing duty, which means there can't be consideration for a contract.
I would look to the Dempster case. It's old, but as far as I can tell, it's still good law. It hasn't been overruled, hasn't been criticized. And that is a case that said that a husband and wife can't enter into a contract where the consideration is the providing of ordinary services. In that case, it was done in an attempt to avoid a creditor claim. But the court was very clear that as a legal principle of common law, there is this duty, and therefore there cannot be consideration.
Well, but I think Dempster doesn't help you because, first of all, the court also nullified this contract on public policy grounds because it was clearly intended to get around creditors. But the duties, the services were unspecified. And here, the district court has specifically said that one of the services was, for example, laundry. That's in the uncontroverted facts. And I think everybody watching this argument wants to hear you make the legal claim that one spouse can enforce the other spouse to do the laundry.
Well, I don't think I'll go that specific.
You don't have a case on that. And these, see, I think the weakness in your argument is that, you know, there are these criminals, there's a criminal statute about support, and there's all that, but that's at such a base level, and these are very specific services to be performed no more than 5 hours a day. They're itemized. They're clearly necessary based on the doctor's identification of the physical injury that the husband had. And I can't see where you could enforce making the spouse do the laundry or these other smaller services. It's, nobody's on the curb dying from lack of food. But, their clothes may be dirty.
Well, I'm going to switch the focus on that just a bit, Justice Biles. I don't think that what I'm saying is that one spouse could force the other to do the laundry. What I am saying is that the spouse that does the laundry can't go to court and make the other spouse pay for it. Because that's what we're talking about
But there's
here.
a statute here that says that these services, if they need to be provided on, with the other conditions,
You can.
you paid an insurance policy to get those benefits.
And your uncontroverted facts are the converse of what you just said. The uncontroverted facts in this case are that the spouses didn't do one another's laundry before the accident.
Right, and
And you said that didn't matter under your chain coming from doctrine of necessaries.
No, I don't think it matters. What I'm trying to say is that the underlying principle here is that an expense cannot be incurred unless it becomes legally enforceable.
You're saying that if Royce had, take the insurance claim out, if he had refused to pay his wife, she could not have sued him for breach of contract.
Correct.
What about other kinds of claims that are sort of quasi-contractual, like promissory estoppel? Couldn't she have made a claim that she relied on his promise of payment and she took time off work and therefore she suffered a loss? I mean, why wouldn't she be able to make those kinds of claims?
I don't believe that would be allowable under Kansas law, Your Honor, and I haven't seen a case that would suggest it would be.
Do you have a case that says it's not allowed?
I'm sorry?
Do you have a case that says it's not permitted?
Not a specific case.
Because your argument hinged on consideration, but there are other legal theories of relief that don't require consideration.
Well, I think that at the same time, promissory estoppel, quantum merit, what have you, require an obligation to...
It just requires reliance on a promise and a loss incurred.
I don't think it's enforceable within the marriage relationship, Your Honor. I really don't think Kansas law would say that that was the case.
Is your case limited to the marital relationship?
The
point made in the concurring opinion, if a couple cohabitated for 20 years, this wouldn't apply. You have engaged couples typically living together prior to marriage. Your argument wouldn't apply to those.
It wouldn't, Your Honor, and I think there's a case called...
Go ahead. No, go ahead.
Marriage of Sedbrook, which is at 16 Canap 2nd, 668, talks about the requirement to provide spousal maintenance following divorce. And it says that if the one of the spouses gets remarried, that duty ends because the duty of support ends and it shifts to the new spouse. And so that case says, but that case then goes on to say, if they had just lived together, then that wouldn't have changed the support obligation of the first husband. And so I think it is key that the marriage has to be entered into. Marriage still has some significance under
When
the
you say
law.
support, you mean like spousal support or alimony? Is that what
Yes.
you're talking about? Yeah.
Yes.
Okay.
Just so I'm clear, counsel, if you win this case, the message that would be sent to people in Kansas is, instead of paying my spouse $25 a day to take care of these issues, I can hire someone for $100 a day and have an expert say that is reasonable amount to be paid for these extra services, and your insurance company would gladly pay it.
Well, I think it'd be capped by the statute at the $25.
Okay.
But certainly, if there were reasonable and necessary expenses incurred by hiring an outside party to come in and provide these services, then certainly the insurance company would have to pay.
And
So
the
you-
public policy at issue here, which makes it different from the Dempster case, is what?
I don't think it is different from the Dempster case myself. I mean, Dempster said you can't have a contract between spouses for the providing of ordinary expenses. Justice
Well,
Biles.
I thought, as Justice Biles was explaining, a distinction between Dempster and this one is that there was an attempt to defraud creditors, and that's why they entered into this agreement. There's no evidence of that here.
No, absolutely not, and I wouldn't claim that. I would take a little bit of issue with that being the holding of Dempster. I think the public policy talked about in Dempster was the public policy of not allowing spouses to contract with each other, whether or not it's in the context of defrauding creditors.
And that case from 1902 is one of the cases you're relying on for that
Certainly, yes.
statement. All right.
Yeah.
Any further questions?
No.
We've taken a lot of your time with our questions. Would you like 30 seconds to wrap up, or do you think you've made your points?
I would just say, Your Honor, there certainly is a small amount of money involved here. And as far as I'm concerned, they can have their $2,600 or whatever it is. But I think that in order to give that remedy, you can't do it narrowly. You would have to do it in a way that calls into question, at least, 100 years of Kansas common law and statutes that rest upon that common law. And I think that should be done with caution, and it probably should be done legislatively. That would be my final comment.
Thank you, counsel.
Thank you.
Please, Court. I have to address the fact that I believe Geico is trying to have it two ways. You can't simultaneously say that you can't have a contract for these things because there's no consideration because there's a pre-existing duty, but then say, well, no, there isn't. I mean, these are inextricably attached. That either you're arguing that the wife has this duty to do these things, period, or not. And if she does have some kind of legal duty to do the laundry, if you will, then, and if that's true, if it's true that there is some pre-existing common law duty for the wife to do the laundry, then Royce Williams should be able to sue her in court for not doing the laundry. I don't think that's true.
Counsel, let's step back from duty for a second. And my question is, why shouldn't we just presume that married spouses will do these kinds of things for one another without being paid? Why shouldn't the law just start with that presumption?
I think because not everybody does their laundry. I mean, and as simple as that is, that's the reality of it.
So your argument is that the law should have no presumption about marital spouses performing any task in the family unit without being paid.
No, that is not my argument. My argument is that this I don't think should trickle into talking about. I don't think you have to have that to prove economic
Well, let me
loss.
just ask real quick my follow-up question back to sort of the old law school, would you paint my fence? If you're going to paint my fence regardless because it's like a Tom Sawyer situation and you think it's fun, and then I pay you on top of it, haven't I really just given you a gift?
I enjoy my job, but I also don't know how long I do it without getting paid.
No, but my question is, if you're going to paint the fence no matter what, because of whatever reason, then you get paid on top of it. Isn't that payment in the eyes of the law nothing but a gift?
I think if I agreed to do it beforehand without the expectation of payment, maybe that would be true.
And I guess that's my question. How do we know that this $25 a day was not actually a gift?
One thing that I'm going to be 98% sure that's in my uncontroverted facts is that Mary Williams had an expectation of payment to do these things. So she, under the facts as they are now, she had that expectation of payment prior to doing it. And to your promissory estoppel argument, had she not agreed to do it with the expectation of payment, in that case they would have potentially made a different choice, gone out into the marketplace and hired that out.
If we were to find that a spouse had a legal obligation to, let's just do the laundry, and in the next PIP case that comes along, wouldn't the insurance company be able to argue that the cost for hiring a third party to come in and do the laundry was not reasonably incurred because somebody else had a legal duty to do that?
I could see that absolutely
And
happening.
that's the spouse.
I could see that absolutely happening, which in my opinion is the danger of using the doctrine of necessaries in this case as support at all. Because if you do that, then the next thing you're going to see is Blue Cross Blue Shield denying a claim because the spouse has an obligation to take care of medical costs. And I don't think that makes sense under the law either.
Do we have any further questions? Does that conclude your presentation?
Yes, Your Honor.
What are you asking us to do?
I'm asking you to find that Mary Williams did not have a pre-existing duty to provide the services she did to Royce Williams and to award Royce Williams the payment for substitution benefits under the Kansas Automobile Reparations Act as they incur genuine economic loss. Thank you, Your Honor.
Thank you, counsel. We thank both of you for your arguments this morning. Court will take this matter under advisement.